Hi, I'm Jeremy Scher. I'm a senior counsel in the litigation department of Bond, Schoeneck King. I'm going to talk a little bit about the confusion that can arise over getting served with process, meaning the papers that initiate a lawsuit. So if you run a business of any kind, whether it's a corporation, an LLC, an LLP, a not-for-profit, then you have likely registered to operate your business with the New York Secretary of State. And that means that an individual who wishes to sue your business can serve process, typically a summons and complaint, upon your business by delivering those papers to the Secretary of State in Albany. The Secretary of State is then supposed to mail the papers to the address that you have on file with the state. But what we're seeing now is that the Secretary of State's office is backlogged, which means that it is not sending process to anyone quickly enough for defendants to actually receive the papers and know that they have been sued in time to avoid a default. You get 30 days from the day that a plaintiff delivers the papers to the Secretary of State to submit some sort of answer or motion in the action. And again, those 30 days can pass before you ever get the papers. Alternatively, there are occasions where a plaintiff will hire a process server to bring papers to the corporate office directly and deliver them to someone, often asking, I need to talk to someone who's authorized to accept legal papers or legal process. And sometimes businesses aren't designed to handle those requests. So someone will accept the papers and say, yes, I can take those, and doesn't forward them along properly. And again, if your time runs out, and you can get as few as 20 days to respond if you're served in that way, you can be subject to a default. If you are subject to a default, that doesn't necessarily mean that you lose the case, but it is disadvantageous. In some cases, the plaintiff may be able to get a judgment against you without even getting a judge involved in the case. In certain cases, the plaintiff may be able to go directly to the county clerk and obtain a judgment, again, with no judge being involved. And that occurs in cases where the lawsuit is for a specific, generally contractually fixed number, such as on a promissory note or on a contract that has a liquidated damages clause that sets a precise damages figure if there's some sort of breach. So you can see how these problems can multiply. If a plaintiff brings a lawsuit on such a contract with a fixed damages number, you don't get the papers in time, or you don't handle the papers efficiently and you don't get your lawyers involved, then you may end up getting a judgment issued against you without your knowledge until the plaintiff attempts to enforce it against your business. So the moral here is we have to be especially vigilant these days in terms of checking to ensure whether there are any lawsuits pending against your business. And we can do that as your counsel, or you can do it yourself if you want, by checking the New York State Court's e-filing website, which is free and accessible to anyone, including non-lawyers, and allows you to look up any filed action in any county of New York that has an e-filing system. And that's most large counties in New York, including Erie County, Monroe County, and Onondaga County, along with the entire city of New York and many other counties. If you do find out that you've been sued late because papers come in the mail and the time period is already passed, then you need to get counsel involved immediately to get that default lifted in order to avoid some seriously disadvantageous consequences in the lawsuit. In any case, Bond Schoeneck litigation attorneys can ensure that you're not caught off guard by a lawsuit and that you're in a good position to assert your defenses on a timely and effective basis.